Hello folks, welcome to another edition of Take 5 Tuesdays. This is the third in our series on the Renaissance of estate planning. The supposition in this series is that because most of us were taught that estate planning was estate tax planning, and because we've had nearly a decade now of very high estate tax exemptions, so few people are subject to estate tax, that estate planning has become unimportant and we have lost the impetus to include estate planning in our basic portfolio advice. The problem is the clients still care about it. The clients have worked a lifetime for what they've accumulated. They love their family dearly. They want the best for their children and grandchildren, and to the extent that wealth can help their children and grandchildren achieve better lives, safer lives, more fulfilling lives, they want their inheritance to have such an impact. The problem is there are threats to these goals. Basically, divorce, creditor protection, long-term care costs, and still, for some, estate taxes are all threats to the ability for clients to leave a meaningful inheritance to their children. I have 2 daughters. If one of them were to marry, any meager inheritance that I would leave to them would be lost to a divorcing spouse, or a portion of it would probably be lost if they divorced their spouse. One of my daughters is a professional. If she were subject to a professional liability suit, any inheritance that I leave her directly might be subject to the claims of her creditors. They both drive cars. You know how many hundreds of thousands of car accidents there are in this country every year. If they own real estate, a slip and fall, any kind of creditor claim could threaten the ability of any assets that I leave them to improve their lives. If we leave the assets to them in a trust, they do not own the assets. Our creditor can only take what we own, but a well-designed trust will mean that my daughter does not own the assets, and their creditor or divorcing spouse cannot take them. They can still control the assets as trustee, as co-trustee, in other ways. But if they operate the trust right, the trust is well designed, their divorcing spouse or their creditor cannot get to the assets. Should they suffer a long-term care event, should they need Social Security benefits, again, a well-designed trust can protect those assets from a long-term care event or from the need to spend down to qualify for Social Security benefits. If you own it, your creditor can attach it. If the trust owns it and the trust is well designed, that is not the case. So we offer to you that you offer to your clients that you consider estate planning in the portfolio advice that you offer to clients. In the next section, we'll talk a little bit about how you can help your clients and yourself and your practice when you include estate planning advice in the portfolio of advice you offer clients. Until then, please take care of yourself, take care of your family, and take care of your clients.